Assistance of counsel in a criminal case guaranteed by the Sixth Amendment to the U.S. Constitution, but what does it really mean? Well, that takes us to this week's case. It involves a real man. He was being prosecuted for mortgage fraud, and he had a counsel who was there, an attorney who was there representing him, Stanton Levinston. And as the case went forward, Stanton was there, of course, every day in the courtroom representing his client. But unfortunately, upon occasion, Stanton was falling asleep. Well, he said he wasn't actually falling asleep. He said in some instances he would just close his eyes to concentrate. And in other instances, he said, well, maybe I fell asleep for about maybe 30 seconds occasionally. Members of the jurors who were later asked, some said that he fell asleep as much as 20 times for short periods of time. Others said maybe a few times. So it was unclear what was taking place, but it was apparent that his full concentration wasn't on this case. Well, his client was convicted. After the conviction took place, his client then brought a motion, a post-trial motion, to the trial court and said, I was denied assistance of counsel because I had a criminal charge brought against me. I am entitled to assistance of counsel under the Sixth Amendment. I didn't get it because assistance of counsel includes not just showing up, but actually being engaged and, for all intents and purposes, obtaining competent counsel in my defense. Well, the judge heard this very simple request and looked at the evidence that was submitted, indicating that, in fact, Mr. Levinston had, upon occasion, nodded off here. Whether he was asleep remains to be seen. And the judge said, you know what? You are right. You are right, Mr. Defendant. You were denied assistance of counsel because you did not get effective counsel here, someone who was effectively and competently representing you, and accordingly, I'm going to grant to you a new trial. And so he was, in fact, granted a new trial. Now, Mr. Levinston, in his defense, as I said that it was antihistamines that were causing him to be somewhat drowsy. He also said that he did close his eyes to concentrate. But let me say this, as someone who has tried cases, trying cases is extraordinarily rigorous. It requires an awful lot of energy, a lot of focus and concentration, because it's not just what's taking place in the courtroom, it's what's taking place outside the courtroom. And outside the courtroom, you have hours and hours of preparation. As one attorney once pointed out to me, he said, you know, you get one moment of brilliance, but in order to get to that 1 million moment of brilliance, you've had to have 10 hours of preparation. And that indeed is the case. A terrific amount of preparation goes into this, and my guess is that Mr. Levinston was, in fact, extraordinarily fatigued and that the antihistamines may have put him over the top. But what we learn from this case is when an attorney is basically doing the best he or she can do and still can't fully concentrate and still can't fully engage in a good representation, at least with regard to criminal cases, there is a guarantee that that should not occur, and someone, as we saw here, can be granted a new trial if it's shown that the attorney was not fully engaged, fully competently representing their client. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.